Meeting of the Pennsylvania Public Utility Commission for the year 2018 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Let me just note for the record, we do have 5 commissioners. Commissioner Sweet is joining us by telephone. Also,
and I am on, Madam Chair.
Thank you, Commissioner Sweet. Also, please note that our safety message that we are normally reading, or I am normally reading, is listed in our bulletin today, and I will give you a reminder each time to check, not the bulletin, the agenda today. So our first matter on this morning's agenda is the approval of the minutes of March 1st, 2018, and I recognize Commissioner Coleman as the editor.
Thank you, Madam Chair. I have reviewed the minutes of the March 1st, 2018 public meeting, and I move that they be approved as submitted.
You have heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Kennard. Any further discussion? Any further edits? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0. Moving on to this morning's agenda, I call up our Director of the Office of Special Assistance, Cheryl Walker-Davis, who will lead us through this morning's agenda.
Thank you, Madam Chairman. Good morning. Good morning, Commissioners.
Good morning.
Good morning.
May it please the Commission, on behalf of your various offices and bureaus, we present for your consideration and disposition the following agenda items, commencing this morning with matters on behalf of the Commission's Bureau of Audits on page 1 of the public meeting agenda. It is recommended that the Commission adopt the recommendation to release the audit report pertaining to the UGI Utilities, Inc. Gas Division's Low-Income Self-Help Program for the 3 years of 2013, 14, and 15.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Office of Special Assistance, it is recommended in omnibus fashion that the Commission adopt the items, commencing with that at the top of page 2, involving the recommendation in the application of James Black Water Service Company, continuing through the items on page 2, as well as the items on page 3 and page 4, and concluding with the recommendation in the matter involving the application of All Blue Taxi Service, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion?
Madam Chair, on All Blue Taxi Service, Inc., when it is time to vote, I would like to be recorded as aye, concurring in result only.
Thank you, Commissioner Sweet. Do we want to divide that out? No, okay. We're continuing on with the motion. All those in favor say aye.
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 Any opposed? The motion passes 5-0, noting that on All Blue Taxi Service, LLC, Commissioner Sweet would like to be recorded as result, concurring in result only.
On page 5 of the public meeting agenda, we offer for the Commission's consideration the recommendation in the matter involving A. Edward Schwartz versus Norfolk Southern Railway Company, PennDOT, Lackawanna County, and La Plume Township.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman to call up the matter for consideration. Under discussion.
Madam Chair, I have a motion.
Vice Chairman Place.
Thank you very much. Madam Secretary, we ask that our joint motion be placed into the records if I had read it in its entirety. Before us today are the exceptions of A. Edward Schwartz to the recommended decision issued by the Administrative Law Judge David A. Salapa in this matter. Mr. Schwartz is a property owner who alleges that the value of his property has decreased as a result of a commission order that directed the abolition of a crossing consisting of a bridge across the railroad which bisects his property. The crossing is gone, the railroad remains, and the land is separated with approximately 70 acres on one side of the railroad right-of-way and 30 acres on the other. His filing was actually an application for a finding that his property was taken, and a determination of the amount of the taking belongs in the Court of Common Pleas. However, because there was no property appropriated in this case, the application was treated as a complaint. Mr. Schwartz accepts to the finding in the RD that this commission is without jurisdiction to find that the abolition of the crossing constitutes a taking where there has been appropriation of property. PennDOT filed a motion to strike the exceptions, or in the alternative, to reply to the exceptions, and Norfolk Southern filed reply exceptions. Both parties point out that the Commission's jurisdiction is to condemn property in conjunction with the construction, relocation, or abolition of a crossing, and to then refer the case to the Court of Common Pleas for a determination of the compensation for the condemnation. The Commission's statutory authority does not extend to granting the Commission the authority to address claims that a rail highway crossing project may affect the value of adjacent property. The recommended decision contains a thorough and correct discussion and analysis of the subject matter and the appropriate outcome, and therefore, we move that the exceptions of Mr. Schwartz be denied and the recommended decision be adopted in its entirety. Therefore, we move that 1, the exceptions filed by A. Edward Schwartz be denied, 2, that the recommended decision of Administrative Law Judge David A. Salapa be adopted in its entirety, and 3, that the Office of Special Assistants prepare an order consistent with this motion. Thank you.
You have heard the joint motion of Vice Chairman Place and Commissioner Sweet. Is there a second?
Second.
Second.
Second by Commissioner Coleman. Any discussion?
Chairman, I have a conflict statement that I asked to be entered into the record as if I had fully read it, assuring the parties that Sean Concanon on my staff, who was representing the Pennsylvania Department of Transportation at the time, did not advise me in this matter.
Thank you very much. Any further discussion? Hearing none. On the motion, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended by the motion, is there any objection to taking the previous roll call? Hearing none, the matter as amended passes 5-0.
We offer for consideration the staff recommendation in the matter involving the formal complaint of Liberty Towers, Philly LP versus Philadelphia Gas Works.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Place. Under discussion, I am going to turn it over to Vice Chairman Place to preside. I do have a motion.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
I ask that my motion be spread upon a record in its entirety. As if I read it in its entirety. Before the commission today is the complaint by Liberty Towers, Philly LP, filed against the Philadelphia Gas Works on December 30th of 2016, which alleged that there were incorrect charges on its bill. On March 17, 2017, the ALJ assigned to this case issued a pre-hearing order outlining the procedures for the parties. In it, the ALJ notified Liberty Towers that it needed to have an attorney licensed to practice law in Pennsylvania enter an appearance on its behalf on or before April 5th, 2017. That date came and passed, and no attorney filed a notice of appearance on behalf of Liberty Towers. On July 11th of 2017, the ALJ dismissed the complaint for failure to adhere to the pre-hearing order. Liberty Towers did not file any exceptions to the initial decision. On August 11, 2017, the Commission entered a final order stating that the initial decision became final without further action of the Commission and dismissed the complaint. On August 24, 2017, 8 months after the ALJ order, an attorney for Liberty Towers made an appearance on behalf of it and filed a petition for rehearing. The Commission's regulations require partnerships, corporations, and other business organizations, including limited liability companies, trusts, associations, agencies, political subdivisions, and government entities to be represented by attorneys in adversarial proceedings before the Commission. This matter was an adversarial proceeding. Accordingly, Liberty Towers, a limited partnership, was required to be represented by counsel. It was notified of the need for it to retain counsel on March 17, 2000, in the March 17, 2017 pre-hearing order. Liberty failed to comply with the pre-hearing order. Failure to comply with an order issued by a presiding officer warrants dismissal of the application or complaint. In its petition for rehearing, Liberty Towers asserts that the reason for the case dismissal was its failure to retain counsel by April 5th, 2017. And now that this failure has been cured, it should be granted a hearing on the case. Under Title 66 of the Public Utility Code, Section 703G, the Commission has the power to amend or rescind its own orders at any time, subject only to the requirements of due process. Because such relief may result in disturbance of final orders, a petition to amend or rescind a final order must be granted judiciously and only under appropriate circumstances. I do not agree with Liberty Towers that it should be granted a rehearing. In my view, the reasons for failure to adhere to the ALJ's pre-hearing order are without merit and do not show cause. Liberty Towers had ample time to obtain legal representation, yet it chose not to until the very end of the process. Due to Liberty Towers' disregard of Commission regulations, I believe it is inappropriate to grant a rehearing. Therefore, I move that the petition for rehearing be denied and the Office of Special Assistance prepare an opinion and order consistent with this motion.
Having heard the motion, is there a second?
Second.
Seconded by Commissioner Kennard. Any discussion? Hearing none, all those in favor signify by saying aye.
Aye.
Any opposed? The motion carries 5-0. Gavel is yours.
On the matter as amended by the motion. Is any further discussion? If not, is there any objection to taking the previous roll call? Seeing none, the matter as amended passes 5-0.
Continuing with the presentation of items on behalf of the Commission's Office of Special Assistance, we're now on page 6 at the top. It is recommended that the Commission adopt the recommendation in the matter involving the application of Justin Joseph Jalbert, TA Skookie Rides Referral Service.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
We offer for your consideration the recommendation in the matter pertaining to Alfredo Caraballo versus PPL Electric Utilities Corporation.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Under discussion is Vice Chairman Place.
Yes, Chairman, Commissioner Sweet and I have a motion on the matter. Madam Secretary, we would ask that our motion be placed into the records if I had read it in its entirety. Before the Commission today is the initial decision of Administrative Law Judge F. Joseph Brady and the exceptions and replies to the ID. In his complaint, Mr. Caraballo sought a payment arrangement after receiving a termination notice from PPL. The initial decision found that Mr. Caraballo's Customer Assistance Program arrearage of $1,571.32 and pre-program arrearage of $1,485.68 were not eligible for a commission-ordered payment arrangement. The initial decision also noted that Mr. Caraballo had only made a single payment between June 7, 2017 and the hearing date of October 6, 2017, evidence that he had not established good faith efforts to pay his electric bill. Based on payment history and evidence of multiple payment arrangements entered into with PPL, on which Mr. Caraballo had defaulted, the initial decision concluded that Mr. Caraballo would be unlikely to meet the obligations of a commission payment arrangement and thus declined to grant one. Mr. Caraballo filed exceptions on 4 grounds. 1, he disputes the actual amount of the arrearage because he believes it is based on estimates. 2, he disputes the finding that he has not established good faith in his payments. 3, he disputes that he testified that he could only pay $100 to $150 per month total for his electric bill. And 4, he disputes that he would necessarily default on a commission-ordered payment arrangement. PPL filed reply exceptions in which the company denied the complainant's claims. By this motion, we move that the exceptions be granted in part and denied in part. In his first exception, Mr. Caraballo objects to the amount of his arrears because he believes that the billing has been based on estimates. However, PPL established that Mr. Caraballo's account is served by an AMI meter that sends actual readings to PPL so that his billing is based on actual readings, usage, and not on estimates. Mr. Caraballo did not believe that his meter was equipped with automatic meter reading capability, and accordingly, his personal knowledge that no meter reader came to his house on the date indicated on his bill is an actual reading led him to his conclusion. We move that this exception number 1 be denied. The second exception is to the ID's conclusion that prior to his complaint, Mr. Caraballo had accrued an outstanding balance of $7,428.82 after defaulting on multiple payment arrangements from PPL, and therefore Mr. Caraballo had not shown a good faith effort to pay his bills. However, it is important to note that Mr. Caraballo was placed on an on-track PPL's customer assistance program during the litigation of a prior formal complaint. In that case, here his arrearage was $9,087.07. As he reduced his arrearage from that amount on April 2015 to $1,571.32, as noted in this case. It appears that his willingness and success in reducing his balance is not in question. Accordingly, his second exception is granted as he has shown a good faith effort to pay his electric bills. His third exception concerns his willingness or ability to sustain a payment arrangement that exceeds $100 to $200 per month, including current usage. He claims that those figures represented what he should pay according to Schuylkill Community Action of Pottsville. He offers to pay a greater amount if that is what the Commission considers to be fair. At his income level, which is less than 150% of the federal poverty income guidelines, he would be eligible for the longest time allowed by statute to repay his balance, which is 60 months. His non-cap arrears divided by 60 payments results in approximately $25 monthly added to his current usage. We move that this exception also be granted. The fourth exception states that he disagrees with the conclusion in the ID that he would default on any payment. Although he presents statements regarding his upgrades to his house and actions that would decrease his electric usage to bolster his claims, these are raised for the first time in exceptions. As they are extra record statements, they are not appropriate for our consideration. His record of defaulting on the payment arrangement given by the utility is difficult to ignore, and we move that this exception be denied. However, the fact that he has paid down his arrearage from $9,087.07 in 2015 to the present level persuades us that he should be given one more opportunity to pay his non-cap arrearage. Mr. Caraballo should be aware that the Commission is bound by law to grant only one payment arrangement per arrearage, which means that he must pay his bills on time every month. The Commission is not empowered to give him another payment arrangement on the present arrearage. Therefore, we move, 1, that the exceptions of Alfredo Caraballo are granted in part and denied in part consistent with this motion. 2, that the initial decision of Administrative Law Judge F. Joseph Brady in this matter is reversed in part. 3, that PPL Electric Utilities Corporation shall bill Alfredo Caraballo by adding 1/60th of his non-cap arrearage to his monthly bill until the non-cap arrearage is paid in full. 4, that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the joint motion, Vice Chairman Place and Commissioner Sweet. Is there a second?
Second.
Can't second your own motion, Commissioner Sweet.
Second.
But Commissioner Kennard did give you a second. So, any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0. The matter as amended. Is there any further discussion? Is there any objection to taking the previous roll call? Hearing none. The matter as amended passes 5-0.
It is recommended that the commission adopt the recommendation contained in the remaining item on page 6 pertaining to the joint petition for approval of an amendment to interconnection agreement of Verizon Pennsylvania LLC and Level 3 Communications LLC, and continuing with the 2 items on page 7 and concluding with the item pertaining to the joint petition for approval of interconnection agreement in the matter involving the United Telephone Company of Pennsylvania LLC, DBA CenturyLink, and Bartel USA Inc.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Bureau of Technical Utility Services, it is recommended that the commission adopt in omnibus fashion the items commencing with that at the top of page 8 in the proceeding involving the application of Time Clock Solutions LLC to commence services as a telecommunications competitive local exchange carrier as well as an inter-exchange carrier reseller, and continuing with the items on pages 8, 9, 10, and 11 through and including the security certificate filed by Aqua Pennsylvania, Inc. for approval of the issuance of debt in an amount not to exceed $50 million.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to page 12 of the public meeting agenda and the matter presented on behalf of the Law Bureau, it is recommended that the commission adopt the recommendation of the Law Bureau pertaining to the policy statement on combined heat and power.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion, I do have a statement. Before the commission is a proposal to finalize the pending policy statement regarding the combined heat and power, or CHP. This proceeding was originally kicked off through the joint motion of myself and former chairman Robert F. Powelson. CHP offers a variety of benefits. First and foremost, CHP supports environmental stewardship through increased efficiency. Also, it provides economic benefits to its adopters through reductions in energy consumption. Further, it supports reliability and resiliency as a distributed energy resource. With this policy statement, the Commission formally acknowledges these benefits and encourages utilities to support the development of CHP by evaluating and implementing new strategies, programs, and other initiatives to promote deployment. Additionally, in an effort to inform the Commission and interested stakeholders, this policy statement requires biannual reporting from utilities detailing information relevant to CHP. This information will help to frame future policy discussions associated with this important technology, and I am proud to offer my support to this policy statement. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And turning now to matters presented on behalf of the Commission's Office of Administrative Law Judge, commencing on page 13 of the public meeting agenda. With regard to the first item, we offer for consideration the initial decision of ALJ Gould in the matter involving the formal complaint of Geraldine Weston versus Philadelphia Gas Works.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Under discussion,
Chairman, I have a motion on this matter.
Commissioner Coleman.
I would ask that my motion be entered in the record as though I read it in its entirety. For disposition is the initial decision granting the formal complaint of Geraldine Weston against Philadelphia Gas Works. The complainant alleged that PGW had terminated service for charges that she was not responsible for. The presiding ALJ concluded that the complainant was not responsible for the entire outstanding amount and directed PGW to remove a portion of the charges from the total balance for the service addressed. The relevant material facts are as follows. The complainant is the owner of the service address at issue. In September of 2014, the complainant was hospitalized, later discharged to a rehabilitation facility, and had not returned to the service address by the time of this decision. PGW continued to provide gas service after the complainant's hospitalization until its termination of service on July 20th, 2015, due to the non-payment of the outstanding balance. The portion of the charge from September of 2014 through July 2015 was $1,640. The complainant acknowledged that neither she nor the authorized representative ever contacted PGW to terminate or otherwise suspend her gas service. She stated that she was unable to do so due to health problems and that no person had power of attorney over her affairs. PGW's witness testified that they would have addressed this issue and the complainant would have avoided this liability if they had been contacted. The presiding ALJ acknowledged that PGW violated no regulation or order of the Commission or any provision of the Public Utility Code. Nevertheless, the ALJ concluded that because the complainant had not, in her view, benefited from PGW service after she was hospitalized, that the charges associated with this time should be removed from the outstanding balance. More generally, the assertion that the customer received no benefit when they were not physically occupying the service address is simply wrong. The premises in question received gas heating service from PGW during at least one winter. Homes that are not heated during the winter are at significant risk of negative consequences such as ruptured water pipes that can lead to structural damage and expensive repairs and restoration. More broadly, under the holding that makes physical occupancy a precondition for billing of service, a customer of record would not be required to pay for service provided to unleased rental properties, second homes, newly constructed homes for sale, properties that have been condemned as unfit for occupancy, etc. While I sympathize with the personal circumstances of the complainant, PGW did act appropriately in billing this customer for the service period in question. In fact, the relevant controlling regulations cited by PGW and acknowledged by the ALJ in this case provided that the customer who wishes to have services discontinued to give at least 7 days' notice to the utility. In the absence of such notice, our regulations provide that the customer is responsible for the services rendered. The initial decision also would appear to conflict with the case precedent that provides that for services-related complaints to be sustained, a utility must have been found to have violated its duty to the customer. Linchpin in the ALJ's analysis was the customer did not benefit from the service because she was not residing in the service residence, even though she was a customer of record. Given the controlling regulation and relevant precedent, the fact that the relevant is not merit in this complaint. In closing, I would reiterate that we all sympathize with the complainant who, due to unforeseen circumstances, incurred significant financial liability associated with the utility service. It is reasonable to consider whether the Commission can craft remedies that would mitigate the consequences experienced by these customers. However, we are also obligated to follow the applicable regulations governing the provisions of utility service, which were deliberately crafted in a way to balance the interest of all customers in public utilities. Excusing customers from the responsibility of paying their utility bills for periods when they are not physically occupying the service address would inevitably shift the financial liability for services rendered to other customers, and this would not be in the public interest. Therefore, I move that the initial decision is reversed and that the complainant be dismissed with prejudice consistent with this motion, and that the Office of Special Assistance prepare an order consistent with this motion.
You've heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed, Madam Chair.
The motion passes 4-1, noting the dissent of Commissioner Sweet. On the matter as amended, is there any objection of taking the previous roll call? Seeing none, the matter as amended passes 4-1, noting the dissent of Commissioner Sweet.
It should be noted that the next two items involving the initial decision of ALJ Dunderdale in the matter pertaining to the complaint of Vertus Dillon versus UGI Utilities, Inc., as well as Deputy Chief Administrative Law Judge Pell's initial decision in the matter involving the formal complaint of Eugene A. Haygood versus Philadelphia Gas Works, have been postponed until the Commission's public meeting of April the 19th. Turning now to page 14 of the public meeting agenda, we offer for your consideration ALJ Salapa's initial decision in the matter involving the formal complaint of Lori Laux versus Metropolitan Edison Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Under discussion, I am going to turn it over to Vice Chairman Place to preside.
Thank you, Chairman. I'd like to recognize Chairman Brown for the purposes of her motion. Chairman Brown.
Actually, I'm going to read my motion in its entirety. Before the commission today is the complaint of Lori Laux seeking a payment arrangement and alleging, among other things, incorrect billing. Metropolitan Edison Companies, or MedEd, or the respondent answers denied the allegations. All parties appeared at the November 15, 2017 hearing. Following the complainant's completion of her case in chief, but prior to the completion of the hearing, there was a technical problem with the telephone conference line. The hearing was continued to January 11, 2018. On January 10, 2018, the ALJ received a fax from the complainant requesting a continuance due to her receipt of a 3-page proposed exhibit from MedEd's counsel on January 9, 2017. The complainant claimed that she needed more time to dispute the exhibit. The ALJ denied the request for continuance at the start of the January 11, 2018 hearing and held the hearing without the complainant present. It should be noted that the pre-hearing order required that documents or exhibits to be used at hearings be provided 5 days in advance of a hearing to both the presiding officer and the complainant. There is some reason whether this requirement was met, as the complainant indicated that she received the exhibit late, but the utilities certificate of service indicated this service was timely. This confusion, when added to the technical difficulties with the telephonic hearing, weighs in favor of granting the continuance that has been requested. The complaint was dismissed for failure to meet the burden of proof that rests, at least in part, on the complainant's failure to appear and address the matters at the second hearing. The complainant appeared at the first scheduled hearing, which was not completed through no fault of her own. A reasonable request for continuance made by a litigant who has made a good faith effort to be heard should not be summarily dismissed. The continuance should have been granted and the hearing should be resumed at the point of interruption to avoid duplicative effort on the part of both the complainant and MedEd. Additionally, it is asked that the record be corrected to reflect the complainant's actual monthly household income, which is exclusive of Supplemental Nutrition Assistance Program, or SNAP program, and exclusive of child disability payments. Therefore, I move that 1, the denial of the complainant's continuance request on January 10, 2018 be reversed. 2, the matter be remanded to the ALJ for further proceedings to be resumed at the point of interruption on November 15, 2017. And 3, the Office of Special Assistance prepare an opinion and order consistent with this motion.
Having heard the motion, is there a second?
Second.
Seconded by Commissioner Sweet. Any discussion on the matter? Hearing none. All those in favor signify by saying aye.
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 Any opposed? The motion carries 5-0. Chairman, the gavel is yours.
On the matter as amended, if there's no objection, we'll take the previous roll call. Hearing none, the matter as amended passes 5-0.
We offer for the Commission's consideration ALJ Haas's initial decision in the matter involving the formal complaint of JYF Partners versus Pico Energy Company.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Under discussion.
Madam Chairman, I have a joint motion between you and I that I'd like to have placed on the record as though I read it in its entirety.
Commissioner Coleman.
On September 25th, 2017, the complainant JYF Partners filed a formal complaint against Pico Energy Company, alleging that Pico placed an unpaid balance from the tenant's account onto its account following the discovery of a foreign load condition at the subject property. JYF requested the Commission direct Pico to recalculate the bill and transfer the amount attributable to the tenant back to the tenant. Pico filed an answer and preliminary objections to JYF's complaint. In its answers, Pico admits that it transferred the balance from the tenant's account to JYF's active account upon discovery of the foreign load condition. PECO avers that a technician discovered that service to the separate shed on the subject property was connected to the tenant's meter accordingly. PECO transferred the tenant's balance in the amount of $751.64 to the active account held by the complainant. The answer requests that the commission dismiss the complaint as legally insufficient. The ALJ granted the preliminary objections and dismissed the complaint without a hearing. Based on the allegations made at the complaint, it appears that the subject premise is a single-family home individually metered for the tenant's use with a shed in the yard that the landlord used for storage. Generally, in Section 1529.1 of the Public Utility Code provides that if the public utility learns that a residential building contains one or more dwellings that are not individually metered, that the account for the premises is to be placed in the landlord's name. The legal question at issue appears to be whether the single-family home with a detached shed or garage is used by a single tenant was intended to be covered under Section 1521 and 1529.1 of the Code. Section 1529.1 establishes very important protections for tenant ratepayers. The Commission has developed a lengthy body of precedent in applying this provision, and we're very familiar with the examples of customers being improperly assigned responsibility for utility service and of other tenants, residents or not, or for common areas within buildings. In such cases, it is difficult, if not impossible, for tenants to recognize whether foreign load exists without the assistance of an electrician. However, in this case, involving load from an entirely separate structure, which allegedly was reserved for the exclusive use of the landlord, does not appear to fall clearly within past case precedent. PECO's position may prove to be the correct one, but we're not reasonably certain at this time that the General Assembly intended for the statute to be applied as it is here. Therefore, we do not agree with the granting of the preliminary objections. Accordingly, we believe it is appropriate to remand this matter to the Office of the Administrative Law Judge for evidentiary hearings, for fact-finding, verifying the nature of the service to this address, and that the parties can address the legal and policy concerns that have been identified. Therefore, we move that the ALJ's initial decision be reversed consistent with this motion, that the matter be remanded to the Office of Administrative Law Judge for further hearings, and that the Office of Special Assistants draft an opinion and order consistent with this motion.
You have heard the joint motion. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion?
Madam Chair, if I might.
Commissioner Sweet.
This is essentially a matter of statutory construction and an attempt to glean the intent of the General Assembly on the foreign load issue. My reading of the statute differs from the analysis that is made by the joint motion. And in fact, I would agree with the analysis of the administrative law judge in the initial instance. So I will be voting in the negative on this motion.
Thank you very much. Any further discussion? Hearing none. On the motion, all those in favor say aye.
Aye.
Any opposed?
Opposed? Negative.
The motion passes 4-1, noting the dissent of Commissioner Sweet. On the matter as amended, is there any objection to taking the previous roll call? Hearing none. The matter as amended passes 4-1, noting the dissent of Commissioner Sweet.
Madam Chairman and Commissioners, that does conclude the presentation of regular agenda items. Turning now to the carrying agenda, it is recommended on behalf of the Office of Special Assistants that the Commission adopt the recommendation pertaining to the petition for reconsideration in the matter of involving Pike County Light and Power Company and Leatherstocking Gas Company's Focus Management and Operations Audit and Implementation Plan.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
On behalf of the Bureau of Technical Utility Services, it is recommended that the Commission adopt the recommendation in the matter involving PennDOT's application for alteration of an at-grade crossing and the associated allocation of costs in Baldwin Borough, Allegheny County.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And on behalf of the Law Bureau, it is recommended that the Commission adopt both the recommendation in the matter involving the petition for declaratory order of Pennsylvania Waste Industries Association, as well as the petition for reconsideration of the Commission's order establishing temporary rates while determining the effects of the Tax Cuts and Jobs Act of 2017.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that does conclude the presentation of agenda items.
Thank you very much. If there's no further business to come before us, and without objection, the meeting is adjourned.